Hello, everyone. Thank you so much for being here. We're excited to have you here. Before I introduce our guests and get started, I do need to do a little bit of legal housekeeping. Let me go ahead and get that up on my screen here. Just a minute. We've had a little technical difficulty today, and I appreciate everyone's grace in making sure that we can get this information out to you. And those of you on the recording, thank you so much. We're glad you're here, even if you are not live with us. So here we go. I do need to share our disclaimer today. Advice Chaser is not a registered investment advisor. We cannot and do not give financial advice. The presentation you see today is for educational purposes only. And let me go ahead and get the rest of my script up. Boy, it is one of those days today, folks. Here we go. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We're thrilled to bring you this educational presentation today. Excuse me. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenters will answer those queries during our question and answer session as appropriate. If you ask a question in the chat box and we don't have a chance to get to it, go ahead and leave your phone number as well, and we will make sure someone reaches out to you after today's event to make sure your question is answered. So I'd love to introduce you to today's moderator and presenter. David Eads is the founder of Vital Investment Management and holds the designation of Certified Financial Planning Professional. Since he was 8 years old, Dave has had an affection for investments, which started with a fourth grade stock picking project at his elementary school. Dave possesses extensive experience in tactical investment strategies, comprehensive financial planning, and tailored retirement planning. Having spent many years in the investment industry, he can devise unique strategies to manage his clients' investments and personal finances effectively. Dave works hard to create a mutually beneficial and long-term relationship with his clients and their families. And Dave is in the northern Colorado area, but serves people all throughout the country. And Dave, why don't you go ahead and say hello so we can see your face?
Hello, everyone on the webinar.
We're so excited to have you here to moderate.
Thank you.
Our presenter today is Will Byers. Will is a native of northern Colorado, and his practice focuses on estate planning, elder law, special needs planning, and Medicaid and VA issues. Will is licensed to practice in Colorado and has been accredited by the Department of Veterans Affairs to handle VA claims. Will is a member of the Colorado Bar Association, Elder Council, Wealth Council, the Larimer County Trust and Estate Section, and the Larimer County Young Lawyers Association. His monthly columns on elder law issues can be found in the Larimer County and Weld County editions of 50 Plus magazine. Outside the office, Will is an avid Colorado Avalanche fan. He loves skiing outdoors with his wife and son and their golden doodle. And Will, I'm going to go ahead and turn the time over to you, and we're excited to get going on this.
All right. Well, thank you once again for having me, Marche, and thank you, Dave, for being willing to moderate this. So as Marche has relayed, really the focus of today and what I'm going to be spend some time sharing information with you on is estate planning and how it pertains to the long-term care planning realm. And so just to give really a foundational background, estate planning is one of those umbrella terms that is thrown around by lawyers a little too frequently at times, but the way that I view it is really estate planning involves wills, trusts, whatever vehicle you use to determine where your property is going to go and who's involved. And additionally, healthcare documents, healthcare powers of attorney, HIPAA authorizations, and as will certainly relate to today's topic, financial powers of attorney as well. And so for those unfamiliar with what powers of attorney are, what their purpose is, those are essentially the documents that state if you are incapacitated, who you would like to act on your behalf. And so if you hear me refer to an agent under a power of attorney, that refers to the individual that you name to act on your behalf. So for example, I have my wife, Alex, named as my primary agent on my financial and my healthcare powers of attorney. And so really as an agent, if I were incapacitated, she would be able to go and access my 401k, or if there were any business dealings that she needed to meet with someone about, that financial power of attorney would grant her the access to do so on my behalf if I'm unable to do so. So that is, kind of a broad overview of what estate planning entails, and kind of circling back to, the will versus the trust discussion. It's something I could certainly talk about for hours and the merits of both, but for purposes of today, I'll give you kind of a brief synopsis of what each is, what they do, what the advantages, disadvantages are. So a will is essentially the document that only comes into effect upon your death. And so a will essentially says where you'd like your property to go, in what rations or how you'd like the pie split up, so to speak. And then also importantly, it lays out who you would like to be involved in the administration of your estate. So once you're gone, that personal representative, or, I believe some call it the executor, executrix. Some states use different names, but essentially the role is who it is that is petitioning the courts to grant the estate's letters, which then gives the personal representative the ability to deal with third parties. And, obviously, if you just go in without documentation to a bank and say, hey, my father passed away, I want access to Jim's accounts, they're going to say, what legal authority do you have? And that's where those letters testamentary come in. And so again, that all comes back to the job of the personal representative that you name in your will. A trust, on the other hand, is, it's really kind of a more advanced counterpart to a will. It does the same things and then some. So a trust is a living entity that you can create. And so just for purposes of giving you an example, if I set up the Byers Family Trust, I am essentially bringing into existence a bucket. And within that bucket, I will put my assets and my family's assets. So I will prepare a deed to put my house into the trust. I will put my bank accounts. I can work with my investment advisor like Dave and say, hey, let's get the ownership updated on my investment accounts so that they're in the name of the trust. There are certain assets that you don't ever take out of your own individual name, the most common being retirement accounts. Reason being that that would be a liquidation event and the IRS would have a lovely letter for you telling you that you owe them a whole lot of money. So we avoid doing that, making that easily avoidable mistake. But, as far as those accounts, we tend to just, name the spouse as the first beneficiary, and then we'll name the trust as the secondary beneficiary. And so really the whole concept behind having a trust and why you would want one is you want to get all your assets in one place. You really want everything to funnel through that bucket, because that is the most effective way for you to control where your assets are going and how they're to be distributed, and who's to be involved once you're either incapacitated or you're dead. And so that is, and one of the other benefits of a trust too, is that if you have funded it correctly, if you've put all your assets in this bucket, there's nothing in your individual name, then your kids or your spouse or whoever it is that would be administering your estate, they actually don't have to open up probate. You've kind of front loaded the probate process. And so you've saved yourself thousands of dollars on the back end, and there's no need to go to a court to get their approval to go ahead and start divvying up the assets the way that the person who created the document sees fit. So again, we've kind of touched on the powers of attorney in the healthcare documents. There's really two branches to the power of attorney limb of the tree, if you will. And so there's the financial powers of attorney, which we touched on briefly. And then there's also the healthcare powers of attorney. And so similar to the financial powers of attorney, a healthcare power of attorney is once again going to name an agent, oftentimes multiple agents, whether acting in concert or you name a backup for your spouse and then a backup for your son or your daughter or whoever. And again, that agent would be the individual who would make decisions on your behalf if you were incapacitated and unable to do so. And so that's kind of a brief conceptual overview of what goes into the estate planning process. Now moving on to the long-term care component. So really, long-term care it can mean any number of things, but generally the way that we approach it and that we view it is what I would imagine a lot of you would think of when hearing a phrase like long-term care. It tends to be anywhere from that time period of, it could be mid-50s in certain cases to 80s, 90s, 100 years old. But essentially it is whenever mom or dad or even, a sibling gets to a point in their life where they are starting to explore additional help and seeing what the options are. And so kind of on the lighter side of it, the entry level, if you will, there is the options of some families, they'll move mom and dad into their house and they'll, kind of make sure that they're taking their prescriptions each day and that they are, always able to, get around if they need to. A lot of them, a lot of times mobility issues are kind of the first, the first wave of this issue. And so if that's an option and it's appropriate for everybody involved, that's a great option to have. Unfortunately, that is not always an option for everybody. And so kind of the next step on the progression is exploring the options for in-home help. So there are a number of organizations, both federal and private, that will offer the opportunity for you to pay individuals to come in and provide nursing care. They may not even provide nursing care. Sometimes they just need company. They need individuals to ensure that the laundry's getting done, that the yard's getting maintained. And then, there often are times where you will need a registered nurse or, a certified nursing assistant, something with a little bit more background and specialties. But that is, a good initial option, certainly prior to looking at options outside of the home. And so once you get into that arena of, you've reached the, hopefully in concert, you've reached the conclusion with your parents or your family members that, hey, unfortunately, living at home is just not the best option for ensuring that there's a safe living environment, which that in and of itself is always a difficult road to cross. But a lot of people, they get to that junction and they decide with mom and dad that, hey, they're in their 80s now. They're experiencing some expected decline, whether it's cognitive, whether it's physical, or both. But at that point, you can start looking into assisted living facilities. So assisted living facilities are they're kind of like long-term care light. So they are really there to provide help if necessary. They provide some structure and typically are going to always have a nurse on staff or multiple nurses. And so, if a family member falls, if there's a situation where all of a sudden they need some unanticipated help, then you have people on site who can provide that. And it's kind of a mix between, the freedom that all of us as adults want to enjoy, but also having that backstop of there's healthcare, there's specialists on site if necessary. The kind of the final step on the progression, and certainly the most extreme, but is a very common one, is skilled nursing. So a skilled nursing facility is going to provide some consistent level of skilled nursing care, which the typical situations are somebody is completely immobile. Somebody has a severe cognitive decline, whether it be dementia, whether it is a neurological disorder like MS or Parkinson's, any number of those. But obviously, it is it's the highest level of care. My grandmother personally, she was in long-term care for 9.5 years, needed round-the-clock care. She had a stroke, and within about 2 months, it had really kicked her underlying dementia into overdrive. And so she was essentially a vegetable. I mean, it's tough to say that about a family member, but that's really what the reality of it was. She was unable to care for herself, unable to move, to feed herself, to communicate. And so that's really, certainly the extreme level of a skilled nursing facility and long-term care, but it's a surprisingly common one. And even if you're not at that level of, round the clock attention being needed, a lot of times these are going to be the most extreme cases where it's abundantly clear to everyone involved that mom or dad cannot be living at home and have it be a safe environment. So assisted living, again, that is, going to the financial side of it. The costs associated with it, they certainly vary from state to state, but I've always been told that Colorado is a pretty strong median as far as where these values lie. And so assisted living around here, certainly depending on the bells and whistles, as with any sort of purchase, you're going to have a variety where some of them provide minimal level of care, and it's about $3,000 a month. And of course, that's typically including the living arrangement. So you kind of think of it as a kind of a rent/care bundle. And you're going to be looking at anywhere from $3,000 to $4,000 to $6,000 to potentially $8,000 in some cases for that. I would say $8,000 certainly on the high end, but for skilled long-term care, you are going to in Colorado right now, and certainly in Larimer County, where I'm located, kind of in the northern Colorado corridor, I am regularly seeing people who are in that more extreme situation and really do need that round-the-clock attention. I'm surprised at this point if I hear of them getting into a place that provides that level of care for less than $10,000 a month. It's very, and then of course, if you're in the unfortunate circumstance where both of your parents need it, it is not unheard of to be spending $20,000 a month between the two of them. And I don't know a lot of people who $120,000 or a $240,000 a year bill is not going to get their attention. So that really kind of leads us into, well, now that the scary reality of it, what can you do to be best positioned? And so I know that lawyers we're inherently bad at giving concrete answers. And so I think I need to lead with, as bad as we are about giving general concrete answers, it's really hard to do it in the Medicaid and long-term care side of it, because the reality of it is we don't know when mom or dad are going to pass. We don't know how long they're going to need this care. We don't know any of the particulars until they strike. And so I really look through this planning through the lens of, I want to give you tools in the toolbox, because I can't tell you exactly what your scenario is going to entail, but I can tell you what I see problems with regularly. I can tell you what I have in my personal, that's the best way to get a good answer from your lawyer, is to ask them, well, what do you have? What do you do? And so really the way that I approach it, both for myself and for my clients, is that I want you to have the right people involved first off. And so, if going to, what you're looking at on the slide, I always say that the more time you have, the more time you give me to kind of get to know your scenario and your family and what your wishes, your concerns are, the better off we're going to be. I mean, that's one of the few uniform, consistent things that I can tell you. If you've been having concerns about, mom's decline, or you're worried about your own decline, even, get a call with an attorney who deals with this realm, because it's very easy to get into your own head about about what's even available to you. And so when in doubt, set up an appointment, because this is a very easy value add for me, because if I charge you $500 to update your powers of attorney to give you long-term care planning ability, and that ends up saving you $500,000, well, that's a pretty good it's a pretty good investment. So that's just kind of hammering home the point of, if you have concerns about this, make the call this week. Don't put it off, because even if one of your parents has received an early onset Alzheimer's diagnosis, that does not close any doors. It really doesn't. And the earlier you get in, the better. Now, kind of furthering on that, and you've set up an appointment, you're meeting with your lawyer to discuss this issue. If they're worth their salt, the first thing that they're going to be asking you is, what documents do you have in place? And if you do have documents, bring them in so we can look over them together. And truthfully, the first document that I look at in these scenarios, without fail, is going to be the power of attorney, the financial power of attorney, because that is really what provides it's really the most crucial component to whether or not there is any planning we can do regarding long-term care. So that is, bar none, regardless of your circumstances, whether you are 18 or you are 80, if you have concerns about, cognitive ability or anything, as far as, there's anything in your life where there's a concern about, hey, who's going to make decisions for this person if something happens? First thing you do is get good, thorough powers of attorney in place. That is really a crucial foundational document, and it's not a sexy document. It's usually relegated to kind of a secondary talking point. But I have all manner of clients, all different backgrounds, who have asked the question of, where do I start? A lot of people are concerned about the cost, and that's totally understandable. And so I say, hey, if you are in that scenario where maybe you have to prolong the planning over time, the first thing that you can do, the best thing that you can do for yourself, is to get updated, thorough powers of attorney in place. And that's a point I really can't emphasize. And so the next step, as far as just kind of the proactive planning side of it, is to get an accurate financial snapshot. And certainly having a good financial resource. So, somebody like Dave, who has their eyes on all the different pots that you have, that makes life easier for everybody. It makes life easier for the client as they are, having these concerns, and they're wading through what they should be doing and what's currently in place. It is absolutely crucial to have a an up-to-date, realistic view of where you stand financially. That is going to be that's going to be a planning component of everything that we do, and certainly how we assess your individual situation. So just an idea of what to expect if you're in this scenario and you set up an appointment with an attorney to discuss, long-term care concerns. I think something to look for is, are they asking you for what documents you have in place, and having them having you bring those in and review them with them, and are they inquiring about your financial standpoint and where you currently are, because what's right for one is certainly not right for the next. And this is an area that one size fits all does not work. And I think that's a good litmus test as far as if you're trying multiple attorneys and kind of getting a feel for them, ask those questions, certainly. So now, and again, I feel like the angel of death in these conversations, because I just get to keep bringing up all these terrible things that can happen if you don't do planning. But guardianships and conservatorships, what are they? How do they apply? So if you are one of the unfortunate clients that I have had over the years and will continue to have as long as I practice, you may think that, hey, we can get the powers of attorney done next month, 6 months from now, next year. Well, life has different plans than we do. And if you are one of those people who's pushed it off and all of a sudden dad has a stroke and it's pretty clear that he is not going to ever be in a position to take care of himself again, well, then a guardianship or a conservatorship is probably going to be your only option at that point. And so as far as how you can remember what powers of attorney do and what their goal is, it can be boiled down to preventing the need for guardianships and conservatorships, because guardianships and conservatorships are court matters, court processes that are really, they become necessary when an individual is incapacitated. Certainly happens all the time in the aging realm and in the long-term care realm. But let's use a scenario. Family, husband and wife, they're in their mid-70s, never got around to doing any sort of planning, don't have any documentation in place. Husband has a stroke, and all of a sudden he's laid up in the hospital and he can't communicate. They don't know how long he's going to be there, but they're starting to say, hey, spouse, he may not ever be able to live at home again. That is certainly a bucket of cold water that happens more often than you would think. And so if this spouse who's trying to kind of pick up all these pieces of this new crisis, finances are always going to be a primary concern. And so if husband has $500,000 in a retirement account and she's going, I need access to that, I need to be able to use this to pay for the care, and she does not have a power of attorney in place, her financial advisor is very unlikely to give her access to that account. And so all of a sudden you have a potential serious obstacle in the way of getting access to the funds that you need to pay for the very care that you're now, looking at. And so if there's anything in an individual spouse's name, and the wife in this scenario, she's not on the account, she's not, maybe she's listed as a beneficiary, but the retirement account is just in the husband's name, you're probably not going to be able to get access to it. And that can be a massive, massive problem if that's a big source of your family's assets. So if you have a power of attorney in place, usually you can just provide that to the, to the group who's managing the assets, and be okay and be able to get access to that and withdraw from that if necessary for this care. But if not, then you're very likely to hear the answer of, well, you're going to need to get some sort of court document indicating that you are allowed to have access to this, and that would be a conservatorship. So conservatorships deal with an incapacitated person's finances. A guardianship pertains to an incapacitated person's day-to-day decision making. So really, for what we're talking about, where they go for rehabilitation or for long-term care, for meeting with their doctors. I mean, if there's not a power of attorney in place and you're having to go through specialists now who are unfamiliar with you and your spouse, they, and this was a surprise to me, but they really don't care if you're the spouse and you're just relying on that to make decisions or to be in the doctor's office with them and be involved. You need some sort of documentation indicating that you are your spouse's agent and that you're the decision maker. Because if you don't have that, then that's where you're looking at having to go to court and petition them for a guardianship. And so, I handle more guardianships and conservatorships than I would like to. And I can tell you that it is far more expensive. It's far more time consuming, and it is very heavily court involved. So not only would you have to petition the court to grant, to have them grant you access to your spouse's bank accounts and investment accounts if they're just in their name, you would also then have to report back to the court yearly every single thing that you are doing with their finances down to the dollar. I mean, it's like having to do your taxes twice a year. So it's not something that you want to have to deal with, because outside of just the cost and the involvement and the court overseeing everything, it is just going to be a huge extra headache that is unnecessary for you going forward. And so cannot stress this enough. If at all possible, get powers of attorney in place, because they, again, going back to, I'm a big value add guy. I don't like when lawyers just kind of, they give you an hourly rate and then they say, well, you'll have a bill show up either next month or, maybe bi-weekly or whatever. I like to relay to people what it is I'm adding to their life and to their financial situation, because that's what I ask of my professionals. And so again, if you pay me $500 to prepare powers of attorney, well, that's a much better option than paying me $5,000 to handle a guardianship or a conservatorship. So that's really the crux of, if you take nothing else away from this entire seminar, update your powers of attorney and get them in place if you don't have them already. So Medicaid. Medicaid, often confused with Medicare, often interchangeable by people who just have the normal person's exposure to it. So Medicaid is the federal program, a needs-based program that will pay for your long-term care if you check all of their boxes. So everybody has access to Medicare in the US once they reach age 65. And so that's really kind of a healthcare supplementation setup. Medicaid is the needs-based setup. So again, not everybody qualifies for it, but they say if you reach certain criteria, the federal government and really your state's your state's organization that's involved with implementing Medicaid and its rules, they will pay for, pretty much everything healthcare related. And so it's certainly a program that you want to at least have the opportunity and have the availability to look into as a potential option if you're in that scenario where dad's he has serious cognitive decline, he can't take care of himself at home, but you have longevity in the family, and all the males in the Johnson family tree, they all live to 95. I've seen it happen. And so when you're looking at that kind of scenario, and you're potentially staring down the barrel of 20 years of paying at least $10,000 a month. That is, Medicaid is an option that you want to at least have some familiarity with, because truthfully, it doesn't matter how many assets a client has when they come in. If they're in their 60s, they're in their 70s, and or even in their 50s, and they say, hey, you know, we've got a family history of dementia, we're worried about this, and we want to make sure that we're keeping all our options open, because really what Medicaid ties into is this goal that so many of my clients have, that say, if we have to go down this road, if we find ourselves in the scenario where we're in a long-term care facility because that's the only option, we want to have the tools available to protect as much of our assets as possible, because we would rather that go to the children than go to the government or go to some large, you know, healthcare facility that we have no connection to outside of being a patient of. And so it, you know, because it is a needs-based program, and because there are so for an applicant to Medicaid, they have very strict asset requirements. And so if I'm applying for Medicaid, the rules as Colorado implements them, and so kind of taking a step back as far as how Medicaid works. So Medicaid is a federal program. Now, with that being said, each state is in charge of implementing the Medicaid rules. And so, as you can imagine, there is some fluctuation from state to state of how they treat it, how aggressive they are in the requirements, and just generally, I mean, just to give you an example, I do Medicaid planning in both Weld County, which is kind of our neighboring county in northern Colorado, and in Larimer County as well. I am going to approach a Weld County situation differently than I am going to approach a Larimer County situation, because there is that much difference between how they run their ships. And so even though Texas is going to have the same general rule, they're going to be operating under the same rules as us. The Texas, you know, Medicaid program, and kind of the trickle down from how their state office mandates and expects the county offices to work, that's going to be different. And same with Nebraska, Wyoming, anywhere else that somebody's going to be going down this road. And so while there is, you know, some difference between how where I'm located is going to treat things differently than California or Florida, the rules are the same. And so just to give you an idea of what those rules are, if I am applying for Medicaid, the restrictions as far as what I can own to qualify for this payment of my long-term care costs and all my other healthcare costs, I can have no more than $2,000 in liquid assets to my name. There are no exceptions for retirement funds. There are no exceptions for inherited trusts. There aren't even exceptions for health or for long-term care policies or insurance policies. If you have those, if there is any liquid value to it, if there is a cash policy value, you know, so essentially, if you could trade in your my life insurance policy, if they say there's X amount of cash value to it, Medicaid will expect you to liquidate that if that's what pushes you over the $2,000 in resources. There is no wiggle room on this one. And so that is just kind of something to keep in mind. Now, I'm fairly certain this is a federal directive, but certainly it applies to Colorado, and I would imagine that it applies to all other states as well. But in addition to the $2,000 liquid assets, you can also have a personal residence in your name, and they actually say that it has to be below a certain value. And last I checked, it was somewhere about $650,000 or lower, which, you know, if you're in the Denver area, or if you're in California, that's something you got to look a little bit closer at. So they will grant you this exempt asset for your home if you fall under these requirements, and you're also allowed one vehicle. So basically how they treat that is they say, okay, well, you own a home, but you have $2,000 in liquid, we looked at your checking account, you just have $2,000, you qualify. But of course, as you can imagine, they are tricky in what they allow themselves to do down the road, is that even though they would allow me to qualify for Medicaid if I check all their boxes and I own a home, they actually reserve the right to file a lien against my home after my death for services rendered. So that can be a real kick in the teeth for people that shows up, sometime down the road. So that's kind of a general overview of the asset expectations for Medicaid. Now, the health requirements, they really will, essentially what they'll do is they need to verify that you are at the point where assisted living or long-term care is appropriate. And so the way that they do that is, somebody from the healthcare facility or somebody from the Medicaid office, they will send out a Medicaid official to essentially do a quick, eyeball test and talk with the doctors to ensure that you meet their healthcare requirements. Excuse me. As far as the Medicaid payback clawback, that was really the filing of the lien that I referred to. And Colorado is a very aggressive state as far as the clawback provision. So I'm fairly confident that if they were footing a long-term care bill for myself for 5-10 years, that they're going to file a lien against my home if I pass away and they've been footing the bill for a while. So how do you qualify for Medicaid without dissolving all of your assets down to get to that qualification? And that's kind of the $1 million question, and really what is the primary concern for a lot of people who find themselves in that scenario and are going, hey, okay, now that we know what we're dealing with, now that we know the playing field, what can we do? It sounds like all hope is lost, but it's not. So just to start, the way that I'm going to plan if there is a spouse involved. So common scenario, husband has a stroke and all of a sudden he has dementia, he's unable to communicate, handle his finances, anything like that. And he's in a nursing home and we're exploring Medicaid options. If there is a well spouse, as Medicaid describes it, who is living outside of the facility, they're still at home, there's a lot more planning that we can do. And we can generally protect about 75% or more of the assets if there is a well spouse and if they've done proper planning. So the first thing that we're going to do, which really relates back to that clawback provision, is we're going to transfer the house into the well spouse's name. Because what that does right away is if you qualify for Medicaid and you have a spouse in the nursing home and Medicaid, they sign off on your spouse and they say, hey, you guys check all the boxes, but they're paying for 10 years of skilled nursing care. Well, that's going to be a sizable bill. And so they would likely try to utilize that clawback provision if this husband is even on the title to the house. And so first thing that we can do is we can transfer the house just into the name of the well spouse. And that is a great first layer of protection because Medicaid is a lot like most of us are, where they really weigh things through the risk reward lens. And so if right off the bat, you can make it more difficult because, well, the person they were paying for is not on the deed to the house, that's good. That's a good start. You want to put up these barriers as far as possible between the family's assets and between a third party, in this case, Medicaid. So furthering that idea, if you have jointly owned brokerage accounts or jointly owned bank accounts, you really want to start getting as many of those assets as possible into that well spouse's name. really, again, just operating from the, the standpoint of, we want to put as much of a barrier as possible between the Medicaid applicant and between the well spouse. Because not only do you have the concern of, well, we want to protect assets for our kids, if at all possible. How's that well spouse going to continue living if they live for another 15 years? There has to be funds available to ensure that they can continue to have a decent quality of life, and that they can continue to, make the mortgage payment if that's, the case, or they can pay for their prescriptions or anything like that. So, really, this all kind of ties back to, well, what can you do in this scenario? And so going back to that ability to protect, 75% plus of the well spouse or of the assets, if there is a well spouse, one of the first things that we're going to look at, and this goes back to the importance of having updated powers of attorney, is whether or not these powers of attorney provide for gifting. And so in Colorado, for example, they've take such a hardline view of this type of planning that they specify within the state statutes that it has to be clearly stated that you are granting your agent the ability to do this sort of planning. So, assuming that you have that sort of language in your documents and in your powers of attorney, you can start looking at the option of converting these assets into income for the well spouse. And so really what this looks like is, if you have $500,000 in liquid assets between the two of you, what you can do, and this involves a lot of number crunching with your lawyers and with your financial advisors. And so if anybody offers you an off the cuff answer of, oh yeah, we can protect this much, be wary, be very wary, because I am going through tax returns and stuff with clients when we're, really kind of finalizing a number of how much we can protect. But once you've determined how many available assets there are, how much you are over that available amount. And so as far as the Medicaid rules go, so we talked about the $2,000 assets available to an applicant. Well, in addition, if there is a well spouse in the picture, they can have about $126,000 to $127,000 in assets for their, it's what's known as a spousal allowance, really. So you can have about $130,000 between the two of them and qualify for Medicaid if there's, if it's a scenario where there is a well spouse. So $2,000 for the applicant, $130,000 between the two of them if there's a spouse in the picture. But going back to what can you do to plan, if you are, roughly $350,000 over that maximum resource limit, what you can do is you can look at what the options are for gifting. And so Medicaid, while they are incredibly hardcore on what the asset limits are, you have a lot more flexibility as far as the income goes. And so the reason we're allowed to do this type of planning is because Medicaid takes a kind of a one-time snapshot of the well spouse's income and resources, really just when you're doing that application to apply for Medicaid. They just take a snapshot of the well spouse's income. And so I always use the example of, if you get qualified for Medicaid and your spouse goes and hits it big in, Las Vegas the next day, and they all of a sudden have $10 million that's coming in, that's okay. I mean, you have a lot of ability, you have a lot of navigability with the well spouse's income, because they really aren't concerned about it after you have applied for Medicaid. And so if that's the situation and you crunch the numbers and you see, okay, we can give away $200,000, right away to the kids, and we can have that amount protected, know that it's out of our resources, and so Medicaid can't touch it. Then the other side of that is figuring out what makes sense for this for an incredibly specific type of annuity that Medicaid, once again, has restrictions over, because even though you do have a lot of wiggle room with the spouse and with their income, Medicaid, if they find out there's an annuity, it's going to have to check a lot of boxes. And I am consistently scared at the information that they have access to, because I've had situations where they've found out a family member has died before the family members have found out. So again, we always just exercise caution and make sure that we're doing everything everything correct. But if you are doing this type of annuity, really the reason behind it is that you want to convert these extra assets into income for the spouse to continue living and to cover this potential penalty period that's going to result because you gave away assets. And Medicaid says, hey, that's a no-no. And that really goes into that 5-year look back period, because Medicaid's rule is if you're going to qualify for Medicaid, you cannot give anything away for less than fair market value 5 years prior to your date of application. And so that's really that's really kind of the, I mean, this is, again, it's a very complex financial setup, and I'm trying to be careful of not going too into the weeds here, but it's very easy to do because it's essentially a financial sleight of hand is really what it is. And you're doing this under the rules that Medicaid has provided. So it's all above board. And I tell Medicaid exactly what we're doing when we're doing this type of planning. So don't fret that you're doing anything, unethical or unlawful, because again, I tell Medicaid exactly what we've done. I disclose the gifts that we've made, but because we've structured things in such a manner to cover that penalty period and to provide an income source to that well spouse, and we've made those gifts, we've accomplished, this protection of assets within the exact parameters that Medicaid has given us. So what roles do trusts play in this? So there are really two types of trusts. And the one that I was describing earlier, the bucket concept, really what I was discussing, for my purposes, if I'm setting up a trust, it's going to be a revocable trust. And 95% of the trusts I create are revocable. Reason being that when you create a revocable trust and you're putting your assets into this bucket, you have a whole lot of rights for as long as you're alive, as far as what can happen to those assets within the bucket. I mean, if it's a joint trust and a spouse, a husband and wife come in and they're meeting with me to do this planning, and we set up a revocable trust, as long as one spouse is living, they have the right to be the trustee. They have the right to change the trust. They have a lot of control and flexibility over what the parameters of that trust are. Now, an irrevocable trust, oftentimes even referred to as the Medicaid Asset Protection Trust, those are a very specific type of tool. And 95% of my clients, if they come in and they're inquiring about an irrevocable trust, it's not going to be appropriate for them. So really, that is, if you are, so kind of my wheelhouse for this kind of scenario and when an irrevocable trust would be appropriate would be if you have a husband and wife who are in their mid-60s, they're in good shape, but they have a family history of cognitive decline, and they are well aware of the costs involved. And they say, hey, we want to get some assets in, know that they're protected in case we do have to look at long-term care around the corner. That's where an irrevocable trust makes perfect sense, because what we can do is we can set up this irrevocable trust, this bucket for their family, where we can put in the house right away. So we can get that out of Medicaid's reaches. And then additionally, we can put in any other assets that, in a perfect world, they're not going to have to access in any way, shape, or form. Because really what you're doing right there is, as soon as you fund this irrevocable trust, you're starting that 5-year look back period. So you're getting a head start. And now the flip side of that, and the potential negative, is that when you set up an irrevocable trust and you fund it, you're giving up right to control those assets. And so that's where it's really crucial that you name, whether it's a child or a family member, who you really trust and who would do what you would want them to do if things went sideways and all of a sudden we thought we had 5 years, but we only have 2. Well, now we have to access these assets. You want to make sure that you have a very trustworthy trustee in that realm, because when you set up an irrevocable trust, you are giving up the legal right to those assets. So I could have easily gone over my time, but I'm trying to be respectful of any potential questions that we have. And so yeah, if there's anything at this point that that somebody would like me to I guess expand on, or if you had questions about it's Medicaid planning and long-term care planning is like drinking from a fire hose. I mean, it is. I frequently see other attorneys' eyes glaze over when I start to kind of get into the nitty-gritty. So please, if you have any questions at all, or if there's anything that I could expand on that would be helpful, feel free to chime in.
Well, we have a handful of questions that have come in here that I'll relay to you.
Sure.
Some of them are more detailed and some of them are relatively straightforward. So I'll try to go through them in that order.
Okay.
Someone other than a spouse or child be designated as power of attorney.
Absolutely.
Okay, perfect. So anyone can be your power of attorney. It doesn't have to be a spouse or child.
It does not have to be a family member. It can be any person that you would want as acting as your agent. And so one piece of advice that I frequently give families is you see this a lot with like 2 or 3 or with multiple children. If there's just this natural tendency as parents of wanting to have everybody involved. That's not necessarily the correct approach, because really the one piece of advice that I can give as far as choosing your agent under your power of attorney is choosing a person that you know and that you trust. If you were outside of the room looking in, that they would conduct themselves, that they would make the decisions that you would personally want to make on your own behalf. So that's something to keep in mind. If you have a child that is incredibly squeamish about medical situations or is terrified of hospitals, probably shouldn't be your healthcare agent. If you have a son who's an infantry medic, he's probably going to be a great choice. So,
okay, that's great. Thank you. And on the power of attorney question that you mentioned powers of attorney earlier, what other sorts of typical services will a lawyer do to prepare you for a long-term care situation?
Most lawyers, not a lot. Truthfully. And the reason being that as soon as you get into the Medicaid and the planning component, it gets infinitely more complex. And so just as I defer to accountants when it comes to a technical issue regarding, tax analysis or how something's to be treated, I know what I don't know, and I don't know. I know enough to be dangerous with taxes, but I'm certainly never going to put my client at risk by saying, yeah, go ahead and liquidate this property. There's not going to be any problem. So I take the same approach when it comes to long-term care planning and Medicaid planning, certainly, because, again, any power of attorney, when rubber meets the road, is going to be better than nothing. So I don't want anybody to go away thinking, oh God, we have to start from scratch. That's not necessarily the case at all. It's just, if you are going into it knowing that long-term care is a concern of yours, make sure that you have an attorney that is well-versed in that.
Okay. Here's the next question. Do you have to reapply to Medicaid every year?
So assuming that this is someone who's qualified for Medicaid, you do not have to reapply. You don't have to resubmit or restart the application process, but they do They do check in, and this varies, but I tend to use the yearly rule of thumb. They will often check in and ask you to resubmit, your bank account statement. And so I always tell people, once you're in, make sure that you keep those accounts under $2,000, because really the way that Medicaid treats it is if you got, so a frequent issue that I've had is somebody gets a small inheritance. Let's say there's an aunt or something that leaves them $2,000, and all of a sudden that pushes them over that $2,000 allowable amount. Well, so long as you spend that in the month that it is received, it is deemed as income, and it's usually a-okay with Medicaid. But once you roll over to, if I receive that inheritance June 13th, and, I go into my attorney and I say, hey, what do I do? I'm going to say to them, just make sure that you have spent that by July 1st, because come July 1st, it's viewed as an asset. So you just want to make sure that that you're staying on top of that and being proactive, because I've heard of Medicaid checking in and they may make a house call, so to speak, and you want to make sure that you're compliant with the rules at that point. So no, there's not a reapplication process each year. Once you're in, you're pretty much good to go as long as you're, compliant with their rules. But don't be surprised if they check in yearly and they ask you for kind of updated statements.
Excellent. Next question here. Does transferring a house or brokerage account to the well spouse's name trigger a penalty?
It does not. So there is no limit to the transfers that can be made between spouses.
Excellent. That was straightforward. How long does it typically take to go to court and get a guardianship or conservatorship?
So under normal circumstances, from the time I have a client retain me and we submit the application and everything and kind of make the court aware of it, to the day that we actually receive the letters and the confirmation that an individual is a guardian or conservator or both, I think 2 months is a pretty fair length of time that I could give somebody and say, hey, this is what you expect. Now, you're always at the mercy of the court schedule. I've had it come up where they have a big trial, that's going to take up a lot of their resources during a week, and we're having to push out the hearing, which is where you go in front of the judge and they make a firm decision on the guardianship or conservatorship. That can be stretched out based on the court circumstances. But one thing to remember is that there are emergency guardianships and emergency conservatorships available if you just have no other options and you have to get access to accounts, or you have to be able to make decisions because mom or dad's in a healthcare facility and they're saying we need to move them. They can't be here any further, but we need somebody with decision-making ability. You can petition the court for an emergency guardianship or conservatorship, and oftentimes you can get a hearing scheduled the following week. Now, as you can probably imagine, I'm going to charge a lot more for that than I am for a typical guardianship or conservatorship, because I'm going to have to completely uproot my schedule. We're going to have to do the same for the court. So they really don't like people playing fast and loose with those emergency guardianships or conservatorships. And because I have to practice in the same courts over and over again, I will have a very honest and frank conversation about whether or not I think it's appropriate. But there are circumstances where that's the most sensible option. And in that case, you can usually get in front of a court within about a week. Now, they will usually issue emergency letters, but they will also, so you can get access technically if everything falls into place. You can get access to those accounts within a week and a half if everything falls into place, but you're not free. The court will say, we're going to set a permanent hearing, in the next 3 weeks, 4 weeks. So you're not out of the woods. There's still going to be the same requirements expected of a traditional guardianship or conservatorship, but it is an option that's available in certain circumstances.
Thank you.
I believe we have time for just one more question.
Okay. Well, this will be the last one. How do you broach the subject with parents who don't necessarily want to talk about the possibility of long-term care in their future?
Oh boy, I'm gonna have to put on my psychiatrist hat for this one. So I'll give you my own personal experience with it, because so my grandfather, my mom's dad, was he fought in Okinawa at 20, came back, started a family, started businesses, just hard as nails. I mean, and so it got to a point where my mom had to have the conversation with him that he wasn't to be driving anymore. And it finally got to the point where my mom was just, walking on coals, trying to figure out how she was going to tell her father that he could no longer drive. And, kind of similarly, where it's like, how do you, that's such a perfect question. And we could go down any number of roads, but, really the best way is to, I think, approach it through the lens of their self-interest and through the family's interest. One way that I've gotten through to kind of the classic curmudgeonly type that maybe they hate attorneys and they hate the idea that they even have to do any of this is I will go to them and I will say, look, I get it. Nobody wants to be in this situation, but would you rather make these tough decisions in tandem with your family members who you care about and who care about you, and with an attorney who is, has a fiduciary obligation to do things in your best interest? Or would you like the court to make these decisions? I mean, that's really those are your options. And if things go south, it's going to be one of those options. But wouldn't you rather exercise some control while you still can and say, hey, this is how I want? Wouldn't you rather have some say in it right now before things really go south? And that's usually, and additionally, if it does, if dad's just committed to standing pat and not doing anything and not doing any planning, well, guess what? There's also going to be fees to third parties involved that you wouldn't have to pay otherwise. So that's more money that you've worked for that's going to pay court fees, that's going to pay attorney's fees, that's going to pay visitors' fees, just so that a third party can make a decision about who's going to take care of you. I mean, I that sounds horrible to me. And so although it's never an easy conversation, I really approach it through the pragmatist lens, and most of the elderly people that I deal with, that gets through to them because they want to exercise control over, their nest egg that they've worked so hard for, that they want to leave to their kids or to charities or whoever. And so I really just kind of take that approach of, look, this is the reality of it. And, I would just tell him, be like, hey, Dad, we love you. We respect your decisions. We want you to have a say in this because we all have an expiration date and we don't know what we don't know what that final road could look like. So why not take the time, put the resources to it to do it effectively now and have it the way that you would want it to be, as opposed to leaving it up to chance.
Thank you. I learned a lot from this.
Thank you so much. Well, we really appreciate your insights and what an important topic. David, thank you again for moderating. If we have not had a chance to get to your question, go ahead and leave your phone number with your question, and we will make sure someone reaches out to you. I'm sorry we don't have more time. Definitely an important topic, but we will definitely have Will and David back. So they're great resources for us. On behalf of Advice Chooser, I want to thank our speakers and the organizations that worked with us to bring you this webinar today. Look for an email soon with a link to the replay of this event. You're welcome to share that replay with your friends and family. Here at Advice Chooser, we're all about helping you find a financial advisor who's a great fit for you and your financial situation. all you have to do is go to advicechaser.com and click on the link to find an advisor. We offer our matching services free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to anyway. So thank you once again from Advice Chaser for being here, and we'll see you at another webinar soon. Thanks, everyone. Bye-bye.